purpose of today is to introduce you to an approach that I've been employing for many years, but I want to impart some of that to you and try to get you to adopt this as a strategy that you use with all your estate planning advisors, not just with financial advisors, not just with insurance people, not just with your clients, but it's a team approach, a collaboration-based approach. My practice at Oden, Feldman & Piddleman is committed to a team approach to estate planning, and in my experience, many estate plans fail because people fail to operate in teams. So if the estate planner operates in a vacuum, or the financial advisor operates in a vacuum without input from the entire team, then the client is going to suffer. And so if one person is the quarterback of the client, and usually it's the financial advisor, and we recognize that in our practice, that the financial advisor is going to be the client interface for most of everything that's going on. Why? Because you're managing their assets. You've got assets under management, AUM. Or if you're a life insurance advisor, you're involved in their life insurance planning. Or if you're a financial planner, you're involved in their lives. Whoever the quarterback is really has a responsibility to make sure that everybody is involved in the process. So my goal is to discover how estate planning is really a team effort, and it requires expertise and involvement of financial and legal professionals. Today we're going to focus on the foundations of estate planning. Stuff, most of this you know already, but we're going to approach it from the standpoint of you dealing with your client. What are the questions that you should be asking your client, and the things that you should be asking the estate planners that you're dealing with? Not just us, but all the other estate planning lawyers around the Beltway that you're dealing with across the country on your clients' issues. My goal is to try to have you figure out what the counseling common issues are. What are you trying to counsel your clients on? What should they be aware of when you're doing your estate planning? We're going to talk about wills as a technique for handling estate planning and why it may be deficient. We're going to talk about revocable living trusts and why it may be much more important that all of your clients in the DC metro area use revocable trusts. Wills are deficient, and I'll explain why. And then we're going to review how these plans are really not effective unless you fund these trusts, unless you put assets in the trust, name them as beneficiaries. You don't want to leave any stone unturned in the funding arena. And again, my goal for you today, understand what the common estate planning counseling issues are. What are your opportunities for additional business out of all of this? How do we generate more revenue for you? It's about embedding you with your clients, but it's also about helping you generate more revenue permanently over the client relationship cycle. One of the things that people leave off the table is the fact that we've got kids of these clients who need to be serviced. Second generation, third generation, and now we're in the fourth generation of some of our clients. And there's a significant opportunity there for planning. The key issues that we're going to talk about are focusing on disability or incapacity. How do you plan for that effectively? Is a power of attorney enough? The answer, no, it's not enough. Particularly in the DC metro area, particularly after the Patriot Act, particularly in light of what the banks require today in terms of authority and powers that you have to have in order to plan for your incapacity effectively. How do you plan for a surviving spouse? What are the issues that you should be aware of? Are sweetheart wills that you can get off of LegalZoom.com enough to plan for a surviving spouse? What are some of the issues that we're going to face? Of course, planning for the kids, grandkids, friends, and family. Tax planning is still important. Income tax planning has become more important than estate tax planning because the exemptions are so high. So what do we do about that? We're going to talk about that. And then minimizing expenses of the estate. That's the goal of everyone. You don't want the estate to be delayed unnecessarily. We don't want the estate to have to pay too much in taxes or expenses after the death of one of our clients. This year we've had a raft of deaths of our clients. I mean, it's unbelievable. Several of my clients who own businesses in their 50s, which is kind of scary for me because I'm in my late 50s, and you never know what's going to happen to us, right? So planning now, we know that it may not happen for 30 or 40 years for our clients, but we don't want to think that way. We don't want to scare them, but we want them to be planning oriented, and we're going to be counselors to them as a team. So, disability. This is really all about when you or your client, as a trustee or the owner of assets, is incapable of managing your financial affairs. What's the best way to deal with this? How will a client be happy in terms of when they are going to be deemed to be disabled? First of all, they don't want to lose control of their assets, right? Never. Our clients never want to lose control of their assets. So what is the best way to deal with this? How do you plan for disability? Insurance is a good way to plan for disability. What kind of insurance? Disability insurance, right? Short-term, long-term disability. We want to make sure that there's plenty of protection for our clients in the event that there's disability. Long-term care insurance is important. Health care insurance is important. But in our documents, to determine whether or not our client is disabled, at a minimum, we want to avoid having to go to court. Always keep that in the back of your mind. So you should say that to your client. We want to avoid having to go to court. A simple formulation is to say that at least 2 licensed physicians, one of whom is your personal physician or your attending physician, have to certify in writing that you're no longer able to manage your financial affairs. But you say, well, wait a second. I don't want doctors making that determination in a vacuum. And that could be dangerous for your family. So you can expand this. As a counselor, you can suggest to your client, that's one alternative. But you could also use a panel or a committee consisting of your personal physician, consisting of your spouse, if you trust your spouse. And it's not always the case that we trust our spouses to do the right thing for us. Yeah, he's disabled. Give me the money. Remember the guy who owns the Los Angeles Clippers?
Donald Sterling.
Donald Sterling, thank you. He was originally declared incapacitated, and his wife, estranged wife, basically took over the estate. They've since agreed not to divorce. In the last couple of weeks, I heard that on the news, which is kind of strange if you think about it. But the determination of incapacity can include a panel of people, and that in addition to your spouse or someone that you trust, a personal physician, you can name a third specialist who might be a specialist in the area that you're suffering from the incapacity to help make that determination. It may require a majority vote, it may require unanimous vote, but these are things that as a counselor you need to bring up with your client if you're sitting down with them and talking about their estate planning. More importantly, a will and a power of attorney do not typically contain enough information or enough instructions about your care or your client's care in the event that you become or they become incapacitated. The best place to do that is in a revocable living trust. We have revocable living trusts. Everyone uses them today, right? But if you look at some of the differences between documents among the different estate planners, you're going to see vast differences in how the issue of incapacity is handled. In most documents today, and I review a lot of other lawyers' documents, the incapacity section might be this much on a page. That's one of the most important issues that we face today. If we suffer a stroke, or if we have a physical incapacity, some event that causes us to be unable to physically manage our affairs, or if we're suffering from dementia or Alzheimer's, what do we want our trustee to do with our assets to take care of us? That might be 2, 3, 4, 5, 6 pages of text. And there's so many issues that need to be dealt with in that regard.